Good evening, everyone. I welcome each one of you to our Advocate on Record Aspirants Academy, that is Golden Jubilee. And today, the God is also showering on us, showing His grace and blessings on us. That see the people even at 5:30, we have gathered here to study and understand what is there in the AOR syllabus. So this is our commitment, and this is our consistency, and because of all of your support, we have reached to greater heights. So I wish that this will go on for many generations to come. So with this noble thought, let me recite the preamble of the Constitution. That is our regular practice. We strongly believe that preamble our unity, preamble our dignity, preamble our sentiment, preamble our commitment, preamble our goal, and preamble our soul. So I request each one of you to recite preamble along with me. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Thank you so much, dear friends. This is one of the leading cases, serial number 86. We are giving more preferences to the newly added case with the effect from 8th of April 2025, a month back. So we are going with the lost serial numbers. 85 is over, 86. TEJ Prakash Pathak versus High Court of Rajasthan. I repeat, serial number 86, TEJ Prakash Pathak versus High Court of Rajasthan. SCR citation is 2024, volume 12, SCR, page number 28. 2024, volume 12, SCR, page number 28. So what is this case about, dear friends? Who is this TEJ Prakash? What is their grievance? Why they have spent so much time in court? So let us understand, let us ask ourselves these questions. So we will be approaching this topic under these headings, dear friends, 5 headings. Please take down. Facts of the case, how the matter referred to the larger bench. Then what was the analysis by the court? What was the issues for consideration before the court? And what was the finding to those issues? Number 5 is conclusion. Dear friends, I repeat, facts of the case, why the matter referred to the 5 judges bench, constitution bench. Number 2, and what are the issues for consideration, and what was their finding to those issues, and conclusion. So based on these headings, I will be dealing with this topic. From the name of the case itself, TEJ Prakash Pathak versus Rajasthan High Court, this itself gives an indication that High Court of Rajasthan is involved. They are the respondents. So what happened, dear friends? Now I am approaching the facts of the case. The Rajasthan High Court came out with a notification in the year 2009. For what purpose? They have invited applications for appointment on the post of 13 post of translators. So High Court of Rajasthan has come out with a notification for inviting applications for appointment of translators, for the post of translators. How many seats are vacant? 13 seats are vacant. Now, we cannot make everyone as a translators. There are certain eligibility criteria. So, eligibility criteria is fixed. Subsequently, how they are selected? They are selected by conducting the written examination and then the interview. Written examination is translation from Hindi to English, English to Hindi. 100 marks each, 200 marks. Thereafter, interview. Interview is to assess the personality of a person. So, in the interview, once it is done, interview was also over. Thereafter, what happened? Results were declared. Once results were declared, for 13 posts, only 3 were selected. Why? Reason is, the then Honorable Chief Justice of Rajasthan High Court has put a condition by saying that only those students or those candidates who has secured more than 75%, not 70%, it is 75% of cutoff will be selected. But it was never there in the notification or the rules anywhere. Is it clear, dear friends? So, this 75% cutoff introduced by Chief Justice after the interview is over. So, it was a shocking both for the candidates, even the interviewers, examiners were not aware. So, 75% was introduced, 3 people were selected. Now, unsuccessful candidates, they filed a writ petition. Against whom? Against the administrative side of the High Court of Rajasthan. If you file a writ petition, you are invoking the judicial side. So, the judicial side of the Rajasthan High Court will look into the correctness of the administrative side, whether the Chief Justice of India has done it rightly or wrongly. That was dismissed. Why that was dismissed? The arguments made by the unsuccessful candidates were this, dear friends. There is a doctrine of rules of the game. The rules of the game cannot be changed in the midway or after the game played. So, rules of the game has to be followed consistently and throughout. It cannot be tinkered with in between. It should not be a shocking news for the candidates. For example, we are all AOR aspirants. Our people are, most of them are AOR aspirants. You all know that 50 marks in each subject, 60 marks in aggregate. Tomorrow, the Honorable Chief Justice of India is saying, the examination committee says, after your exams over, it is only 70% aggregate are declared to be successful. Definitely, it will be a shocking news. If you were already told only 70% is the aggregate, you could have put in more effort. So, only after writing examinations, when it was introduced, it was a shocking news. And what is violated? Doctrine of principle of legitimacy, doctrine of legitimacy. Legitimate expectation, the principle of legitimate expectation that every candidate has. Because in the notification, in the rules, it says only the interview, written examination with certain marks, but not 75%. So, where is it is completely arbitrary. Violation of Article 14. Article 14 says when the employer acts in an arbitrary manner, unreasonable manner, unjust manner, it is a violation of Article 14. So, that is how they said. And Article 16 also. Where is the equal opportunity in terms of public employment? So violation of Article 14 and 16. That was argued by the translator aspirants. But on the other side, on the administrative side of the High Court of Rajasthan, they have argued it is a bona fide decision. Number one. Number two, why we have introduced 75%? The reason is to ensure that candidate is more competent. Therefore, that was their argument. Ultimately, the Honorable High Court dismissed the writ petition. Now they are before the unsuccessful candidates were before the Supreme Court. And it was before a regular bench. Matter referred to the larger bench. Dear friends, you must remember one article. When we say 5 judges or more than 5 judges, it is a constitution bench. Which article in the Constitution of India provides the Honorable Supreme Court to constitute 5 judges bench or more than 5 judges? It is Article 145 Clause 3, which empowers the Honorable Supreme Court to constitute minimum 5, more than 5, minimum 5. For what purpose? For interpretation of the constitutional provisions where it involves a substantial question of law. So you must remember Article 145 Clause 3. Since we have referred to 145 Clause 3, Article 145 Clause 1 empowers the Supreme Court to frame rules by which Supreme Court rules were framed. So the matter referred to the larger bench. Why it was referred to the larger bench? Why it was doubted by the, why it was not decided by the coordinate bench nor regular bench? Regular bench, when the matter came up before them, they have doubted the correctness of Manjushri case. I will tell you what is the exact full name of the case. I will just giving a background. Manjushri case, they have doubted the correctness of the judgment comprising of honorable 3 judges. Why they have doubted the correctness of Manjushri? Reason is, in Manjushri case, they did not refer to the earlier judgment which was decided in the year 1974. Marwaha case. I will tell you the exact case. Now itself I will tell you the. Please write down these 2 cases, dear friends. This entire case revolves around this. Manjushri, K. Manjushri versus State of AP. That is Andhra Pradesh. 2008, Volume 3 SEC, page number 512. I repeat, K. Manjushri versus State of Andhra Pradesh, 2008, Volume 3 SEC, page number 512. In this case, they have not referred to the earlier judgment. Yes. It is the state of Haryana versus Subhash Chandra Marwaha. 1974, volume 3 SEC, page number 220. 1974, volume 3 SEC, page 220. So the regular bench doubted the correctness of Manjushri case by not referring to this Subhash Chandra Marwaha case. So therefore matter was referred to the larger bench. That is how it came up before the larger bench, 5 judges bench. Now what was the issue before the 5 judges bench? Let us see, dear friends. See, they have analyzed, after hearing both the sides, This is what we are going to decide and discuss. They have narrated nearly 6 points, dear friends. Please note down. Firstly, this is very important with respect to service law is concerned. Firstly, when the recruitment process commences and comes to an end, you ask yourself this question, dear friends, then only your mind will operate to give answers. Don't think that we are reading the judgment. If you are sitting in the dais and you are asked to decide this case, your mind operates in a different way. For example, when we started our practice, we were there as a junior to assist the seniors. So at that time, though our preparation was good, it will be up to 50% or 60%. Because in the back of our mind, our senior only is going to argue. But if you are getting your own case and you think that, oh, nobody is there, it is you who has to argue the case, your mind thinks 100 times. If Lordship is going to put this question, how we are going to answer? So therefore, dear friends, don't think that this is a judgment given for the leading case and for AOR examination only. This is going to help us to make us a knowledgeable person. And this is what going to discuss, we're going to make as a distinguished jurist. This is what the one which is going to make us our life. One who read a leading case become a leading lawyer. Take it from me, dear friends. Who is a leading lawyer? A lawyer who knows much better than others. He is a leading lawyer. So one who knows the leading cases become a leading lawyer. So therefore we have committed ourselves to analyze, understand, investigate from serial number 86 to serial number 1. We are going to analyze. But because it is like creating a compulsive platform for us to read together, to grow together. This is a collective growth for the welfare of our country. Reason is, if we are fully updated, we will assist the Honorable Court effectively. If we assist the Honorable Court effectively, we will have quality justice, timely justice, correlated with the preamble, justice, social, economic, political. We the people of India, given to ourselves and to secure to all its citizens justice, social, economic, political. So it is not an individual. Once he reads, it becomes the institution grows. Individual grows, group of individual become community, and the institution grows. This is how you have to take it forward, dear friends. The only sin, if you want to commit, underestimate yourself. I cannot do this. I cannot read this. Where is the time? If lordships have time for writing 300 pages, don't we have time to read this? Ask ourselves this question, dear friends. You ask a right question, you will have a right answer. How can you read this? Put a question. You cannot put a question, how do I justify not to read this? Problem is our origin of thought. If thought is pure, everything falls in place. Now let us read the analysis, dear friends. When the recruitment process commences and comes to an end. Number 2, basis of the doctrine that rules of the game must not be changed. Very important. Rules of the game must not be changed during the course of the game or after the game is played. So whatever the rule you want to say, you tell it before inviting the application. Don't shock the candidates. They should be well ready, well prepared for what they are going to face. So basis of the doctrine that rules of the game must not be changed during the course of the game or after the game is played. See whether the decision in K. Manjushri, dear friends, this is how the matter came up before the larger bench. Whether the decision in K. Manjushri is at variance with the earlier precedents on the subject. That means whether K. Manjushri is contradictory to Marwaha case, Subhash Chandra Marwaha case. That is the question. Now, D, whether the above doctrine, that is rules of the game, applies with equal strictness qua method or procedure for selection as it does qua eligibility criteria. So what they are saying is, when you say the doctrine of rules of the game, it strictly applies to the eligibility criteria. But whether the same strictness applies to the method of selection also, that is the question. E. Whether procedure for selection stipulated by Act or rules framed earlier, either under the proviso to Article 309 of the Constitution or a statute, could be given go by. When there are rules, when there are statutes which prescribes that this is how you have to conduct the method of selection, whether a state can give a go by to those rules and statutes, what is the answer? Finally, whether appointment, dear friends, we have to understand every line, every word has a depth meaning. It's deeply rooted. You cannot just read just like that story. If you see very keenly, we are supposed to see the entire world behind the word. So whether appointment could be denied by change in the eligibility criteria after the game is played. So these were the issues, dear friends. Now let us give ratio to the dissenting. Now we are moving on to findings of the court, how the honorable judges is going to give answers to these questions. Firstly, what is the first question? When the recruitment process commences and comes to an end? Answer is very simple. The process of recruitment begins with the issuance of advertisement and ends with the filling up of notified vacancies. So it will, once application is invited, that is the beginning. Once 13 posts are fulfilled, that is the end. So this is where the process of recruitment begins with the issuance of advertisement and ends with the filling up of notified vacancies. But it consists of various steps like inviting applications, scrutiny of applications, rejection of defective applications, elimination of ineligible candidates, conducting examinations, calling for interviews and viva voce, and preparation of list of successful candidates. So this is the answer given by lordships, and it is a unanimous judgment. No majority, no minority. Therefore, very easy to understand for the AOR aspirants. It's a majority, unanimous judgment. Now moving on to the next question. Basis of the doctrine. What is the basis of the doctrine? Doctrine of the rule of game, dear friends, very important. This is where how honorable judges applying Article 14, Article 16, principle of fairness, principle of legitimate expectation, everything is dealt under this. Please carefully listen. Basis of the doctrine, rules of the game. What does it say? The doctrine proscribing. We thought proscribing means forbid, prohibit, or exclude. The doctrine, rules of the game, forbid change of rules midway through the game or after the game is played. Why? Why that rule came into force? Reason is on the rule because it is against arbitrariness enshrined in Article 14 of the Constitution. Article 16 is only an instance of the application of the concept of equality enshrined in Article 14. In other words, Article 14 is the genus while Article 16 is a species. Article 16 gives effect to the concept of equality in all matters relating to public employment. These two articles strike at arbitrariness in state action and ensure fairness and equality of treatment. So in all its actions, state is bound to act fairly in a very, very transparent manner. This is an elementary requirement of the guarantee against arbitrary state action, which is Article 14 of the Constitution adopts. So what is the basis of the doctrine of rules of the game? The state should not act arbitrarily by changing different rules and regulations after the game is played. So it is arbitrariness, violation of Article 14, violation of Article 16. So therefore, to avoid, to prevent arbitrariness, this rule has come to ensure transparency, to prevent misuse of the power, and moreover, this is based on the principle of fairness. Dear friends, when you are writing in the findings of the court, you must quote findings of the, this is principle of fairness. 14, 16, principle of fairness. But what is there in favor of the candidates? Legitimate expectation. It is called doctrine of legitimate expectation. So this is what the examiners wanting from the AOR aspirants. Doctrine of legitimate expectation, what does it say? Candidates participating in a recruitment process having legitimate expectation that the process of selection will be fair and non-arbitrary. The basis of doctrine of legitimate expectation in public law is founded on the principles of fairness and non-arbitrariness in government dealings with individuals. It recognizes the public authority's promise or past conduct will give rise to a legitimate expectation. When there is a notification which says it has only written examination and interview, there is a legitimate expectation. Once he clears the interview, he will come for the selection. Right? But Chief Justice has introduced 75% cutoff. So it is a violation of the principle of legitimate expectation that everybody, every candidate legitimately expects that they will call us, but 75% has put a restriction. So it is amounts to arbitrariness. That is what their argument is. But when you want to go by to the legitimate expectation, it can be done only in one way, when it is for the public interest. So this doctrine of legitimate expectation, they can put a restriction on this principle considering the public interest. That is important, dear friends. So they have discussed when the recruitment process begins, ends. They have discussed about the doctrine of rules of the game. Now they are moving on to K. Manjushri is not at variance with earlier precedents. So the regular bench doubted the correctness of Manjushri case because they did not consider Marwaha case. But the Honorable Supreme Court has distinguished Manjushri is something different issue. Marwaha is something different issue. What is that issue? Let us see. What is their finding? This is where wisdom of the honorable judges applied, dear friends. What the law declared by them becomes, whatever they pronounce becomes the law of the land. And how they have distinguished, please look at it. The decision in Manjushri lay down good law. So regular bench doubted the correctness of this judgment, but 5 judges bench has said Manjushri is a good law and is not in conflict with Subhash Chandra Marwaha. It is not in conflict. How they are going to differ? Let's see. Subhash Chandra Marwaha deals with the right to be appointed from the select list. Please write down, dear friends. This is where we get confused. Subhash Chandra Marwaha deals with the right to be appointed from the select list, whereas K. Manjushri deals with the right to be placed in the select list. Right to be placed in the select list. These two cases therefore deal with altogether different issues. So you can have two tabular column. One is select list, another one is appointment list. Subhash Chandra Marwaha deals with right to be appointed from the select list. They are asking for the appointment. From where? From the select list. But whereas Manjushri, they are asking to place their name in the select list. So select list is the first step, appointment list is the second step. Subhash Chandra Marwaha deals with the appointment list, whereas Manjushri deals with right to be placed in the select list, that is the first list. So therefore the two cases therefore deal with altogether different issues. Therefore the regular bench could not have raised the correctness of Manjushri because both are two different aspects. They're nothing to do with this. This is why, that is what they have said, K. Manjushri is not at variance with the earlier precedents. Now what is the D, dear friends? D is rule does not apply with equal strictness to steps for selection. These rules of the game will does not apply with equal strictness to steps for selection. Reason is, subject to the rule against arbitrariness, how tests or viva voce are to be conducted, what questions are to be put, and in what manner evaluation is to be done, whether a shortlisting exercise is needed, or all matters of procedure which in the absence of the rules to the contrary may be devised by the competent authority. Often advertisements inviting applications are open-ended in terms of these steps and leave it to the discretion of the competent authority to adopt such steps as may be considered necessary in the circumstances, albeit subject to the overarching principles of rule against arbitrariness contained in Article 14 of the Constitution. Only aspect is whether they have acted in a fair manner, reasonable manner, in a just manner, not violating Article 14. That is the test. I am going to conclude, dear friends, just two aspects, that's all. Procedure prescribed in the extant rule not to be violated. When there are rules which prescribed, those rules need not be violated. The examination committee, they have to follow strictly whatever the rule says. If the rule is silent, then they come under the umbrella of 14 and 16 of the Constitution of India. Finally, dear friends, appointments may be denied even after placement in the select list. Appointment may be denied even after placement in the select list. For example, translators post, how many vacancies were there? 13 vacancies. 21 aspirants participated. How many were selected? Only 3 were selected. Now the unsuccessful candidates might say, we have participated, 13 vacancies are there, only 3 were selected. Why 10 people were not selected? The answer is, appointments may be denied even after placement in the select list. They were not placed in the appointment list, only in the select list. So because reason is to ensure that candidates are excellent, they have ability. For example, instance, there are civil judges, district judges, posts are vacant and participants are more, 1000 people are there. They write their examinations, only 6 were selected. Remaining 50 post vacancy, 6 were selected, remaining 44 are vacant. We cannot claim as a matter of right, or we cannot make even a request that these many posts are vacant, please appoint us. They say no, judicial institution will suffer. We don't want to fill the vacancy just by appointing A, B, C, D. We want to fill the vacancy only when they are eligible candidates, qualified candidates. Otherwise, vacancy, let it be there, no issues. But we will not just appoint the human missions in that place. That we will not do it. We need a qualified person, deserving person. So that is what they have said. Appointment may be denied even after placement in the select list, dear friends. So with this is majority view, unanimous judgment, very important. So with this, I conclude this session for today. Before concluding, dear friends, I request one of our philosopher, mentor and guide, and being a golden jubilee, and he was there throughout, Mr. S.K. Patri sir, I request you to come forward and share your word of wisdom with our AOR aspirants with your big applause, dear friends. You can hold this. You can hold this. Slowly. Yeah.
I am a ceremonial lawyer. He is the real lawyer. So he is our jewel. So whenever I am standing over the jewel, I am sparkling because of his dazzlingness. That is my qualification. He is a great lawyer. In him, I have seen from my early days of practice, his early days of practice, that he is real going to lead the bar someday or other in academic lines, in excellence of our wisdom. He said that I have some more experience. That is right. But one thing I have seen him, I marked him in performance in the court, and what he is doing, perhaps nobody, very few might be doing in their own way, but he is doing it. So today, some one of his followers said that today is 50th day. So I am always not so busy, but today I thought perhaps it is the day I should inspire you all, and I should get inspiration myself also. Because what he is doing today, he is doing great service to the institution. If I am praising him, I am praising all of you, including myself, because I am a part of the system. In him I have seen, because when I see his performance, I'm watching him also for the last 20 minutes or so, I feel inspired. And age is just a number. And we are learning lawyers because always, each day we learn from everybody, and we are learning from a great master. In him I have seen him a great jurist. A judge in him is still sparkling up. A lawyer you have already seen. Academic excellence you have seen. Why I am praising him, he deserves it. And you will like that you have a true guru which you are following him always. And advocate record might be one of the issues, his combining force. But in advocate recordship examination, you will see yourself as a great lawyer, excellent lawyer, leading lawyer. You will be deciding leading cases. Your common sense will grow, and your lifetime achievement you can find from this place. I always say, bar is the mother of everything. Bar can do anything. Mother of the judges, and it is the only. He is a great power. I cannot say he is the Kohinoor, but he is like a Kohinoor. And in him, I have seen so many things. And in you also, if you follow him with some other good lawyers, you will be a great lawyer. And it should be a noble profession. I wish need noble people. There's so many lawyers. It is a huge ocean. Supreme Court bar is a huge ocean. People may come, people may go, people may have so many ideas. But here, some people are like lighthouses. Some people, very few, very few. So among that few, he is one of them. So I am inspiring you because you are already to have a great guru. Whether you become an advocate and record a big lawyer, that is time will say, that is not a big thing, but do it. But you will become a good man, good human being, noble man, noble profession, our institution will grow and you will grow. That is the only thing I have watched all his arguments, and the way he is explaining you. So you will be definitely nothing to be read at all at home more. If you are watching him personally and academically, his book is also there. I have seen it, I have read it in part, not everything. So I'm a stage actor, not in the National School of Drama, though I'm a lawyer there, but I like his performance. And he always come. And something I want to tell the bar this time, because I can tell also, you also can request, it should be glass panels should be raised so that the disturbance will be less. You can do it. And this time the election is on the corner, another 3-4 days after. You just request that at least the glass ceiling should be there so that he will not be disturbed. Because a great lawyer, a great judge, a great academician, if there is some outside disturbances, other aware might be disturbing them. So that should be there. That is simple thing, infrastructural thing. But if follow him like a true disciple, you will be rewarded always. You will become a good human being, good lawyer, good excellence, and good professional ethics will also run by you. And law is the greatest profession in earth, I can say. They are the leaders, and you will be leaders provided you lead them all the way. And he is a leader. I am just getting a dazzling out of him. He is like a sun, I am a moon. So I get the light because of the shining. So it is now moon is coming, so I have to go to National School of Drama to see a movie. Thank you. All the best. I always all the best for him. And he will do wonderful things. I always bless him. I get inspiration. I still learn from him. And everybody learns from each other always. Even from the lawyers, those who are coming today, the interns, those who are coming tomorrow, and also the students who are yet to read, yet study law, even the clients, those who are yet to come to the Supreme Court, we have to learn from them. So it is a learning process throughout the time till life you have to learn. And but not only learn, you have to also practice it. Thank you. All the best. I am happy that Raja has invited me. Extempore, I can speak for hours. I am also a professor, but I cannot teach like him. Thank you, sir.
Thank you so much, sir. Honored by your presence. I would like to quote Honorable Justice Shivraj Patil, a former Supreme Court judge. His Lordship has said, when mind is full of knowledge, it is only a storehouse. When that knowledge is shared with others, it becomes a lighthouse. So, therefore, everybody will share our knowledge to make sure that all our citizens are wealthy, healthy to achieve the objectives enshrined in the preamble, because our preamble, our goal, preamble, our soul. Please join us for group photo. Thank you.